Okay, so hi everybody. Thank you all for joining this webinar. We are excited to have you all here for the custody and child support webinar taking place now. We still have a few people logging in, so we're going to give them a few minutes or so to get settled, but we will continue with housekeeping. Thank you. So again, thank you for taking the time to join us today. My name is Sabrina Azrak, and I will be your moderator for the duration of this webinar. Before we do begin, we want to go through some housekeeping guidelines. So today's webinar is being recorded, and the recording of this webinar will be available afterwards on our website at www.ccmw.com. We welcome you to revisit the content yourself and to share it with your networks. And this point is very important. We do ask that your video camera and your microphone are muted during the webinar. This will help eliminate ambient noise and increase clarity throughout the webinar. And we thank you in advance for doing this. We invite your comments and your questions, and so we will be running a live Q&A session at the end of the webinar using the chat box. Based on the feedback we've been given during our most previous webinar, we've extended the Q&A session by 15 minutes. And the chat box button is a 6 button from the left at the bottom of your screen. And once you click it, the chat box should appear on the right-hand side of your screen. If you think of a question at any point, just type it into the chat box and I will pose it during the Q&A portion. You have two options when you send a message. You can choose to ask a question anonymously by sending the message to myself, and it will say my name and it would also say the host. Or you can choose to send the message publicly, whereas you would just send it to everyone. After this webinar, an evaluation will be emailed to you later today. It will take about 5 minutes to complete, and it would be very beneficial if you could complete it. It will help our funders understand what we were doing, and it will help us as an organization learn what we can do to do better. And if you require any kind of tech support, please feel free to send me a direct message using chat box or by texting me at 416-897-1907. And if I'm responding to messages as I'm reading along, so please be patient with me. And now we'll go on to the vision and mission of CCMW. So the Canadian Council of Muslim Women is a national nonprofit organization committed to attaining equality, equity, and empowerment for all Muslim women in Canada. Founded in 1982, the organization works to promote Muslim women's identity in the Canadian context. For more than 37 years, CCMW has proudly advocated on behalf of Muslim women and their families and developed national projects that enrich the identity of Canadian Muslims, encourage civic engagement, and empower communities. During the past several years, the Canadian Council of Muslim Women has undertaken initiatives to inform Muslim women, the legal profession, community service agencies, policymakers, and the general public about the differences between Muslim family laws and Canadian family laws. Previously, CCMW published Muslim and Canadian Family Laws, a comparative primer in English and French, and Pam, the facilitator, will be going into this in more or greater detail. And it's a series of booklets in several languages on family law topics to further its public education efforts. Our latest project in this field is the Muslim Women's Family Law and Legal Rights Project, and it's updating these documents and disseminating them via knowledge sharing workshops that are at a standstill because of COVID-19. But the intent behind those workshops was to deliver them across cities in Canada for Muslim women, community service providers, the legal profession, and the general public. In 2003, CCMW took the lead in establishing a coalition against religious arbitration composed of over 50 sister organizations, including the National Association of Women and the Law, METRAC, and the WYCA. The No Religious Arbitration Movement and CCMW's work represented an array of complex issues and events. We were successful in that the government of Ontario made a decision to disallow the use of religious family laws under the province's Arbitration Act. CCMW was compelled to inform Muslim women about the choices they have available to them within Muslim and Canadian family laws and simultaneously educate individuals and institutions that assist them or work with them to resolve family disputes. CCMW is composed of a national board that works to further CCMW's objectives at a national level, and 15 local chapters made up of members whose passion and hard work advance the vision of CCMW within local communities. Many of our CCMW chapter members and presidents are on the call today. To learn more about CCMW, please visit ccmw.com. I'm now going to turn it over to Pamela Cross, the facilitator for today's webinar. Thank you.
Thanks, Sabrine. And let me add my welcome to all of you to Sabrine's. My name is Pamela Cross, as she said. I'm a lawyer. I work with a number of different women's equality and violence against women organizations across Canada and have worked with CCMW on a variety of projects over the past several years. The focus of all of my work is on violence against women and the law. I'm honored to be facilitating this series of 7 webinars, which reflect the content in 6 brochures produced by CCMW that provide comparative information about Canadian and Muslim family law, particularly as they pertain to women's rights. The topics covered in those brochures are marriage, divorce, custody and child support, which we're discussing in this webinar, family property and spousal support, domestic contracts, and inheritance. The goal of the written materials, as well as of these webinars, is to assist Canadian Muslim women in being able to make informed choices in the areas of family law in Canada. We hope these resources will also be of assistance to professionals who work with Muslim women in the family court system, students who'd like to know more about these issues, and community-based services that assist women. These are the 6 brochures initially developed in 2006 and updated this past year to reflect the state of the law as it is in Canada now. The content in the brochures is based on Muslim and Canadian family laws, a comparative primer published by CCMW in 2006, and you can look for more information about that primer on the CCMW website. Please note before we begin that the information contained in these webinars, as in the brochures, is just that. It's information. It's not legal advice, and it should not be interpreted as legal advice. If you or someone you know is dealing with a family law issue, it's very important for them to meet with a lawyer to discuss their situation, to provide all the details and the facts of their situation, and then to receive legal advice. The webinars, the brochures, and the primer, we hope, will be very helpful to you, your friends, your family members, clients of yours, as they begin to think about family law issues they're grappling with, but they are not a replacement for legal advice. If you want to find out about the sources and validity of Muslim laws and legal opinions referred to in these webinars and in the brochures, please consult Muslim and Canadian Family Laws, a comparative primer. Laws in a public legal system are in a constant state of flux. They change to adapt to the times. What you hear in this webinar, what you read in the brochures, is accurate to the date of the recording, in the case of the webinars, and to the date of publication, in the case of the brochures. We strongly encourage you to verify that the information contained in the documents or in the webinar is current at the time that you're reading it or listening to it. At the end of my presentation, which will take probably about 30 minutes, as Sabrine has said, we'll have time for questions and answers. I do encourage you to post them as you think of them in the chat area so that you don't forget them as we move through the content of the material this afternoon. Beginning next week, we'll have Professor Omar Farhat joining us to assist in the Q&A section. He is an Islamic scholar, is an expert on Muslim family law. I'm not. The information I'm sharing with you today is based on the material that Omar developed for the brochures. And next week, he'll be here to answer questions that you have that relate specifically to Muslim family law. Traditional Muslim law distinguishes between guardianship of the children and custody or care of a dependent child. Under this system of law, the father has the right of guardianship over children from the time of their birth, but custody, or the right to live with and look after minor children who cannot care for themselves belongs to the mother. The age and conditions of such custody vary, as we'll see, but the principle remains the same. Guardianship speaks largely to the financial support for children. Canada has quite a different system. The children are seen to be the shared responsibility of both parents while they live together. If there is a dispute over custody when the parents separate, it will be decided based exclusively on Canadian family law, which uses the best interest of the child test to make all decisions. And we'll come back to talk about what that best interest of the child test is a little bit later in the webinar. Even when parents make their own arrangements for the children under Muslim laws, courts can refuse to enforce them if they're found not to be in the best interest of the child. That is, courts in Canada. The Divorce Act and provincial territorial laws, in Ontario that law is called the Children's Law Reform Act, and court judgments provide a set of rules, formal and informal, for deciding custody matters. These rules provide significant direction, but also leave room for discretion on the part of the court. Under Canadian law, parents can decide on custody arrangements in a separation agreement, but the courts can disregard that if it's not seen to be in the best interest of the child. One very important side note here. The Divorce Act went through significant changes in a bill that was passed and received royal assent about a year ago in June of 2019. Those revisions to the Divorce Act were scheduled to come into effect on July 1st of this year. However, late last week, the Attorney General and Minister of Justice, Mr. Lametti, announced that implementation of the revisions to the Divorce Act is being postponed until March 1st of 2021. So what we're talking about today reflects the law as it is now. That law will look somewhat different come March of 2021. People have many reasons for choosing under Canadian law to use either the Divorce Act or the legislation in their province or territory to resolve custody and access disputes. Unmarried people have to use provincial or territorial legislation because they're not married, they're not seeking a divorce, and that means the Divorce Act does not apply to them. Even some married people prefer to use the provincial or territorial legislation. They may not be immediately seeking a divorce. Perhaps they can't afford the cost of a divorce, or maybe the provincial or territorial legislation offers them better options in terms of custody and access. Anyone who's trying to decide which legislation is more appropriate, the Divorce Act or the provincial laws, should seek legal advice from a lawyer specializing in family law. But let me reiterate that only people who are married and who have applied to the court for a divorce can use the Divorce Act to also sort out custody and access or parenting issues. Under Muslim law, fathers, as we said at the beginning, have guardianship over their children, as well as the responsibility to provide for them financially. The mother is granted custody of the minor children. The father's responsibility to provide maintenance, financial support, continues whether or not the children live with him. This responsibility includes paying for all necessary living expenses, including education. Guardianship also entails the legal representation of minor children, which we discussed last week in the context of marriage and who can grant permission for a marriage to take place. The guiding principle throughout these doctrines in Muslim law is the child's best interest. The underlying assumption is that a mother is most capable of caring for minor children, whereas a father is more appropriate to be responsible for their financial support. Under Canadian law, guiding principles really reflect what is considered to be in the best interests of the child, regardless of the legislation, federal, provincial, or territorial, that's being used. Custody of children in Canada or parenting arrangements for children in Canada is determined using this best interests of the child test. For example, in Ontario, according to the Children's Law Reform Act, the court must consider, among other things, the child's needs and circumstances, the child's views and preferences if they're old enough to provide those, the ability and willingness of the people, usually the parents, who are applying for custody to provide the child with guidance and education, as well as the necessities of life, including support for any special needs, the ability of each person applying for custody to act as a parent and provide a stable home or family environment, and the relationship to the child of anyone who's applying for custody. The Divorce Act, which, as I mentioned earlier, only applies to people who are married and seeking a divorce, also addresses the care of children after their parents separate. The current Divorce Act uses the language of custody and access. The Divorce Act that will come into effect on March 1st of next year uses instead the language of parenting order. A parenting order assigns parenting time and decision-making responsibility. So come next March, we won't be hearing the terms custody and access in cases that fall under the Divorce Act. Both time with children and decision-making about them under the Divorce Act, as well as under provincial and territorial legislation, can be shared between the parents, so the children could spend roughly equal amounts of time with each parent, and both parents can be involved in making decisions for them, or it can rest primarily with one parent. The kids spend most of their time living with one parent who has the bulk of decision-making responsibility for them, but they spend time maybe every week, every couple of weeks, both in person, online, on the telephone, with the other parent. The court makes its decisions under the Divorce Act about parenting arrangements using the best interest of the child test, which will, in the new Divorce Act, set out specific factors that are to be considered. The current Divorce Act does not stipulate what the factors are within the best interest of the child test, but the new legislation will. And many of those provisions, those factors, are the same as in provincial legislation. In the new Divorce Act, the court will be explicitly required to consider family violence as part of the best interest of the child test, and that new legislation will provide a detailed and expansive definition of family violence. Because it's often difficult for courts to assess what's in the best interest of the child, they've heard from mother's perspective, they've heard from the father's perspective. Each of them says they're the best parent to have the child live with them. The judge doesn't live with the family. The judge doesn't know whose story is more credible or believable. Because of all of that, courts sometimes use a family assessment to assist in determining what the best interests of the child are. These assessments are usually completed by a child psychologist or a social worker who spends time with the children alone, the children together, and in the company of each parent, as well as any other significant adults who play a big role in their lives. In Ontario, the Office of the Children's Lawyer can, if the court orders it to do so, be the entity that develops that family assessment, and then that report is made part of the evidence that goes in front of the judge when the judge is making a decision about arrangements for the children. Where it's not appropriate for the Office of the Children's Lawyer to become involved, the parents can agree on a family assessor and then hire and pay for that person themselves. Similar kind of process. The person will meet with the children, meet with the parents, meet with the children, with the parents, and so on. And then that family assessor's report is part of the evidence that comes in front of the judge when the judge is making decisions about the parenting arrangements for the kids. Under Canadian law, regardless of who has primary responsibility for the children, both parents have a right to information about the health, education, and welfare of their child. This means that a parent who does not have primary care or decision-making responsibility, but has some contact with the child, can ask questions and be given answers about counseling, school report cards and activities, healthcare, and other such matters, whether or not the custodial parent wants that to happen. Most Muslim jurists agree that mothers should have custody until age 9 for girls and age 7 for boys, but some scholars extend it to the age of puberty for boys and the age of marriage for girls. In general, classical jurists tend to believe that girls need to stay in their mother's custody for longer than boys do. Again, according to most classical schools, a mother will lose custody to the father if she remarries. If both the mother and father are incapable of caring for the children, they will go in this order of ranking to the paternal grandmother. If she's not available, then to the paternal aunts. If there are no paternal aunts and the paternal grandmother can't take the children, then the maternal grandmother, and after her, the maternal aunts. A mother cannot move the children to a foreign land or far away from the father's town unless she is returning to her hometown. And the same applies to the father. He's not permitted to move the children away from where their mother is living. Custody and guardianship rights in Muslim law are non-negotiable, since they exist to protect the children's rights, not the parents'. Thus, in a settlement, the mother may not surrender her custody rights to the father, or vice versa. Under Canadian and provincial and territorial laws, care of and decision-making for children is the equal responsibility of both parents until they enter into an agreement or there's a court order that says something different. This means that neither parent can unilaterally take the children and withhold them from the other. So if a woman is leaving her marriage, and even if she's been the primary caregiver to the children throughout that marriage, if she just takes the children, doesn't tell the father that she's leaving, doesn't tell the father where she's going with the children, doesn't make arrangements with the father for him to spend time with the children, she could be in trouble legally. The exception to that is if she takes the children with her because of concerns for their safety. So where there's a history of family violence, she's going to make the argument, I took the children with me because I didn't think it was safe to leave them. Nonetheless, she's expected to get in touch with the father as soon as possible and arrange some kind of contact between the father and the children. Maybe it's a visit that the father can have with the children with his parents or her parents around. Perhaps it's a telephone call initially. But if she just takes the children and leaves and doesn't communicate with the father, he's certainly going to be able to go to court and make an argument that she has participated in a parental abduction, and it's quite likely that the children would be returned to him. Not necessarily permanently, not even long term. It's not a determination of custody at that point, but the court is very likely to say the children have to return to the family home at that point. Once the parents have separated and they're sorting out the custody and access arrangements for the children, then this best interest of the child test is what is used to determine how much time each parent should spend with the children. As with Muslim family law, under Canadian law, the parent doesn't have a legal right to spend time with their child. The child has a right to spend time with their parent in a manner that is in the best interests of the child. So I don't get to spend time with my child just because I'm my child's mother. We have to establish that it is best for the children to spend that time with me. Certainly, under Canadian law, parenting arrangements can be agreed on by both parties in a separation agreement or through mediation. It's not a requirement that people go to court to resolve any kind of parenting dispute. However, as I mentioned briefly earlier, if what the parents agree on is not in the best interest of the child, a court can disregard that agreement. The court, if the people are not able to work out parenting arrangements on their own, can order the parents to share the physical care of the children and decision-making for them. Or it can give those responsibilities primarily to one parent while setting up times the children spend with the other parent. So let's just think of a couple of examples of what that could look like. If the mother, as is most common in Canada, has been the primary caregiver to the children while the parents were together, and she's a good and competent mother, let's say the order then says the children are to be primarily resident with the mother, who has sole decision-making responsibility. And the children will spend time with the father every other weekend from Saturday morning till Sunday afternoon. And he's permitted to have texting, Skype, Zoom, telephone time with them 2 evenings a week between 7 and 8 p.m. Of course, those details would depend on how old the children are and so on. That's one kind of custody and access or parenting order that the court could put in place. Or if the parents have both been quite involved with the children while they were still together, it might be an order that says the children spend roughly equal amounts of time with each parent. It would set out a schedule. So for very young children, it's likely to be a couple of days with each parent. So they move back and forth fairly frequently. With older children, it might be a week with one parent, then a week with another. Decision making might be set out so that the parent who has the child with them is the one who makes decisions during that period of time. The order could say that the parents are to share in all decision making. Now, obviously, that doesn't mean things like what kind of breakfast cereal somebody's eating in the morning when they're living with whichever parent they're with that week. But it would mean things like extracurricular activities. Is this child going to take piano lessons? Is the child going to play soccer or baseball? Are they going to have swimming lessons? All of those kind of extracurricular activities. Educational decisions, French immersion or no French immersion, a religious school or a secular school. Healthcare decisions. Even if the child is ill, there are healthcare decisions that come up from time to time. And religious upbringing. So those are the four main categories of decision making for children, at least as the courts look at it: religion, school or education, healthcare, and extracurricular activities. Parents may be expected to consult and collaborate on all decisions about all areas of the child's life. Sometimes court orders say that one parent's responsible for, let's say, religion and healthcare decisions, and the other parent is responsible for the other two areas of decisions, extracurricular activities and education. That's pretty challenging, though, if the parents don't get along, because really for children, a decision in one area of their life is going to have an impact in another area. For example, if I say that I don't believe that my child requires medication for an attention deficit issue, and I'm in charge of healthcare decisions, but my former partner is in charge of education decisions, my decision about a healthcare issue is going to have a significant impact on the child's ability to engage effectively with education. So you can see that these are complicated issues to sort out. It's very important for people to be working with a lawyer, even if they're going to resolve their issues in a fairly friendly manner. It's very important for people to understand what their rights and responsibilities are. In addition to those general issues around who the children live with, how much time they spend with each parent, and who makes decisions for them, the court may need to take some steps because of safety concerns. If there are concerns for the child's well-being when they're with the access parent, or there are concerns that the parent really hasn't done a lot of parenting and may not know enough about how to be with the child, or perhaps there are concerns the parent might not return the child, then this access time with that parent can be supervised. If I've threatened my partner over the years of our relationship by saying things like, well, you can leave me if you like, but I'm going to take the children and you'll never see them again, that might be a good reason that my time with the child would be supervised, at least initially. Likewise, if there are concerns not about the children when they're with the other parent, but if there are concerns about the safety of the primary parent because the other parent has been abusive, then the exchanges of the children can be supervised. So maybe it's fine for my kids to be with their dad on their own, but he's been stalking me, harassing me, and threatening me. So I don't want him coming to my house to pick the children up, or I don't want to meet him at his house to pick the kids up at the end of the visit. Then the exchanges of our children can be supervised. So that kind of supervision of the access time itself or of the exchanges can be either formal or informal. Throughout Canada, there are formal supervision centers with paid staff who physically supervise either the exchanges of the kids or the time that the children are spending with the access parent. They keep notes about what happens, and if necessary, those notes can be used in court if there are problems and an order needs to be changed. Or the supervision can happen more informally. I am not comfortable being alone with my ex-partner, so the custody order says that I'll drop the children off at his parents' house and he'll pick them up half an hour after I've dropped them off. Or we agree to exchange them in a public place, the public library, a restaurant, a playground. There's nobody there to actually supervise the exchange of the children, but we're in a public place and that increases my safety. It diminishes the chance that my partner will do something abusive to me. Same with the access time itself. It may be that the order says the access is supervised in a formal access center, or it may simply be that the access is supervised by a family member or a friend. Once there is a parenting order in place or a custody and access order in place, that can only be changed if there's been a significant change in the circumstances of the family. For example, I've had sole custody or primary care of the children up till now, but my 16-year-old son has expressed a very strong desire to spend more time with his father. They have a lot in common. If I don't agree with that, and my ex-partner wants to take me to court to change the custody of the 16-year-old son, he's going to have to establish to court what it is that has changed and why it would be in the best interest of our 16-year-old son for that child to now live primarily with his father as opposed to with me, the mother. I think other examples could be if a parent becomes ill, if a parent develops a serious mental health issue, if a parent has a substance use issue that wasn't present at the time that the initial order was made. Certainly the other parent could go to court and say, I'm looking to change the parenting arrangement. Here's what's changed. Here's why we need to do that. Most custody orders made in one province or territory will be enforced in other provinces or territories as long as they're in the best interests of the child. There are both legal and financial consequences for parents who don't follow a parenting order. The police may become involved to find and return the children if one parent keeps them when they're not supposed to have them. So an access parent doesn't return the children at the end of the access visit, or the primary parent doesn't produce the children for access at a time when it's supposed to happen. Orders can also stipulate the conditions under which a parent can take children outside Ontario or Canada, and that can be very important, as we'll see in just a moment when we look at issues of international abduction of children. In spite of the mother's unquestionable right to custody of minors under classical Muslim laws, many modern Muslim majority states have laws that favor the father as a result of a misguided expansion of the concept of guardianship. Furthermore, with minor exceptions such as Turkey, most Muslim majority countries did not adopt and continue not to adopt international legal instruments, which I'll describe in just a minute, that allow international cooperation to return children to their habitual residence in the case that they have been illegally abducted from one parent by the other. Therefore, if a father takes his children to his Muslim majority home country without the mother's knowledge, it will be difficult, sometimes impossible, but not always, to use that country's legal system to regain custody by the mother over the children. Canada is one of the 84 countries that has signed the Hague Convention on the Civil Aspects of International Child Abduction. This treaty is the only multilateral agreement that provides assistance in cross-border abduction. The objectives of the Hague Convention, as it's commonly known, are threefold. First, to deter child abductions. Second, to promote cooperation among countries and their respective authorities. And third, to ensure the prompt return of abducted children to their home country. If a child is removed illegally from Canada to another country that has signed the Hague Convention, the parent in Canada must contact the central authority, that's a capital C, capital A, it's an official title, must contact the central authority here in Canada, which is either the Federal Minister of Justice or the Attorney General of the province or territory where the child was living at the time they were removed. The parent will then have to bring a case to have enforcement in the country to which the child has been taken or from which the child is not being returned. I'm just going to talk our way through the convention and give you a couple of examples to help illustrate how this would actually work. If a child is brought to Canada illegally from a country that has signed the Hague Convention, the case for the child to be returned to that country would be brought in Canada. So in other words, the case happens where the child is now, after they've been abducted. It's important to be aware that in these situations where a Hague Convention case is underway, the court is not deciding what's in the child's best interests. The court is not deciding which parent should have responsibility for the child. The job of the court is simply to determine whether the parent who's asking to have the child returned has what are called custodial rights. If so, and if the parent was exercising those rights, then, subject to some exceptions, the child will be returned to where they were living before they were removed. This is often called the child's habitual residence. Once that has happened, if there isn't a custody or a parenting order already in place, the court in that jurisdiction can proceed to make one based on what is in the child's best interests. The main exception to returning a child is if the parent who has taken the child can establish that there's a serious risk of harm to the child if they were returned. This could include family violence. So let's look at a couple of examples. Mother and father living in Canada, children born in Canada. The family moves to Germany for 2 years while the parents have employment there, or one of the parents has employment there. Germany has signed the Hague Convention. Partway through that period of time, the parents separate. And one of the parents, let's say the mother, says, I'd like to take the children back to Canada to visit their grandparents. The father says, sure, that's fine. Mother says, we're leaving on September 1st. We'll be back by September 15th. Once she arrives in Canada, she says to the children's father, I'm actually not coming back. We've separated. I want to live in Canada where my family is. The children and I are staying here. There's no custody order in place. They've just separated and they don't have any formal arrangement yet. But the father can still bring an application under the Hague Convention. He's going to argue that the children's habitual residence, that phrase I used a minute ago, is in Germany because that's where the family was living at the time the mother took them. That he had custodial rights, that is, he was regularly spending time with his children. He did not consent to the permanent removal of the children from Germany. He was only consenting to a vacation trip to Canada. And in all likelihood, I mean, obviously, there's a lot of other facts that would have to come into play, but in all likelihood, that would be successful. And the children, presumably with the mother, would be returned to Germany. And once back in Germany, either parent could start a custody case in the German court to determine where the children should live, who should be able to make decisions about them. Certainly in that scenario, the father would be using as evidence to support his case the fact that the mother unilaterally removed the children from Germany. Different scenario, couple living in Canada with their children. The mother is actually, let's say, from the United States, but she moved here when she married her husband and the children were born here. It's an abusive relationship. She's decided to leave her spouse, but she wants to go back to her home in the United States. She has family there. She has friends there. She's afraid of her ex-husband. She also can get a job back in the US. So she crosses the border with the kids. They're in the United States. and now the father brings an application under the Hague Convention to have the kids returned to Canada. Clearly, Canada is their habitual residence. Even if there's a custody order in place that says the children live with the mother, as long as the father has access and is using his access, he can bring an application under the convention. The mother is going to argue that the children are safer in the United States, that in fact there would be a serious risk of harm to the children if they were returned to Canada. These are tricky arguments to make because in fact her argument might be primarily that it's not safe for her to return to Canada, and because she's the primary parent, the children should be allowed to live in a place that's safe for her, i.e. the United States. She might or might not be successful. It really depends on the evidence. But those are just a couple of examples of how a Hague Convention case can play out. But please remember that people can only bring a Hague Convention application if the children have been taken from a country that has signed that convention to a country that has signed the convention. If either the children's habitual residence or the place they've been taken to is a country that has not signed the Hague Convention, it doesn't apply to them. Happy to come back to this in the Q&A if you've got more specific or more detailed questions. But we're going to change themes now for a minute and talk about child support. Looked at how decisions are made about where children live. Who pays for what once the parents separate? Under Muslim law, child support is the father's absolute responsibility, regardless of where the children are living or who they're living with. Support should cover all the necessities, including education, and it should increase proportionally over time if the father's financial situation improves. In the event that the father is unable to provide for the children, the mother can attempt to get payments through a court order, or she can request a loan that's guaranteed by the father's assets. In Canada, both parents are expected to contribute financially to the support of their children. In most situations, child support is the money paid by the parent who doesn't have primary responsibility for the children to the parent who does. So using the language of Ontario, by the access parent to the custodial parent. The amount of support to be paid is based on the income of the person who's paying the child support and the number of children. There's actually a chart. It's called the Child Support Guidelines. There's a federal chart, and each province has a chart, and the amounts of money in those charts is slightly different depending on the standard of living in each province or territory. The income of the recipient is not a factor, except in extraordinary circumstances where, say, the custodial parent makes $5 million a year and the access parent is on social assistance. But generally, the income of the parent receiving the child support is not a relevant factor. It's the income of the person paying support and the number of children. That being said, child support is calculated slightly differently if the children are spending roughly equal amounts of time with each parent, because of course in that arrangement, the parents are sharing more and more costs on a more equal basis. It's also slightly differently calculated where some of the children live with one parent and some with the other. The amount of child support being paid can be changed either by the cooperation of the parents or by a court order if there's a significant change in the circumstances of either party. For example, the parent who's paying support loses their job or they get a significant pay raise. It can also be altered to reflect extraordinary expenses based on needs or activities of the child that involve costs above those that are generally considered to be covered by child support. Or undue hardship, although undue hardship is almost never recognized by the court. And there's lots and lots of decisions about this. Very briefly, I can't go back to court and say, I have undue hardship, I should be able to pay less child support because I married someone else and now I'm supporting the 3 children from their previous marriage. On the other hand, if an unusual circumstance arises, let's say I'm paying child support and one of my parents has developed severe dementia, is living with me, and I'm covering the costs of in-home care for that parent, I may be able to have the amount of child support I'm paying reduced on a temporary basis because of this unusual circumstance in my life. If I need to reduce child support, though, because I've lost my job or I've had a cut in pay, I'm expected to go back to court and have the amount of child support recalculated. Generally, child support is paid until the child reaches the age of 18. It can end earlier if the child, excuse me, is no longer under parental control, has married, or has had a child of their own. Support may continue past the age of 18 if the child remains enrolled full-time in school or is disabled and unable to become self-sufficient. Child support payments are not tax deductible for the person paying the support, and they are not taxable income to the recipient. Provinces and territories have child support enforcement mechanisms that ensure people with child support responsibilities meet them. In Ontario, orders are registered with the Family Responsibility Office, known as FRO, which collects the money from the person paying support and pays it to the person receiving it, actually puts it in the recipient's bank account. The FRO has the authority to garnish paychecks and bank accounts, to seize GST, to seize income tax returns, or to suspend a person's driver's or professional license or passport if they are in arrears with their child support payments. All of the provinces and territories have reciprocal enforcement agreements. So just because you have a child support order in Saskatchewan and now your ex-spouse has moved to Nova Scotia, doesn't mean that they can get away without paying child support. Nova Scotia will ensure that those payments are made. And that kind of reciprocal enforcement agreement is also in place between Canada and a number of other countries. One final comment before we open things up to discussion. While not directly related to the breakdown of a marriage, child protection issues do arise from time to time in this context at the time that a marriage ends, especially when there's been violence in the family. These issues are governed by provincial and territorial legislation. In Ontario, it's the Child, Youth and Family Services Act that ensures the safety of children and their families. The Act approves agencies to operate as children's aid societies and to protect children under 18 years of age. Where the Child Protection Agency or society has concerns, it can investigate, provide guidance, counseling, and other services to the family, can supervise children while those kids are still living with their parents, and in the most serious of cases, can remove children from their parents and provide care for them in another setting. So, Sabrine, I'm interested to know what questions people have been posting.
Definitely. Thank you, Pam, for the presentation. So the first question we did receive is, what happens to access if a parent has a criminal history or is incarcerated?
If a parent has a criminal history, that will, so they're not in jail right now, but in the past they've broken the law, that will only affect access if the court feels that it's not in the best interest of the child to spend time with that parent. There are lots of parents with criminal records who have access with their children because it's happened in the past, it was a minor incident, or they've changed their ways, whatever it might be. When a parent's incarcerated, often the access doesn't happen during that period of time, but there have been many court decisions that have said that the mother, or perhaps another family member, an aunt, an uncle, a grandparent, is expected to take the child or the children into the jail or the prison to spend time with their father. This is very challenging for women, especially if the father's in jail for a violent crime, especially if he's in jail for abuse against the mother. I have met a few people, grandparents, who have had to, by court order, take their grandchildren into a prison to visit the children's father, who's in prison for having killed the children's mother. So these can be very, very difficult, but certainly having a criminal record does not automatically mean that the person doesn't spend time with the children.
Thank you, Pam. The next question is, could all of this be sorted out in mediation and get the order through family court?
Absolutely. Where the two people are able to bargain and negotiate with one another, where neither one of them is so afraid of the other that becomes difficult, mediation can be a really great way to resolve child custody arrangements. It's sometimes quicker. It means that there's more likelihood that the outcome will be one that really reflects what's best for this family, because both of the parents have participated in the process of sorting out what that arrangement will be. The challenge with court, and don't get me wrong, court is sometimes the only way to go, particularly where there are serious safety issues. But the challenge with court is that a judge who's a stranger to this family is going to make an order. And that judge may have misunderstood some of the information they've been provided with, may have interpreted it differently than either person wants them to do. Mediation lets the two people working with a trained professional negotiate, have some back and forth, and come up with an arrangement that maybe it's not perfect. Maybe they don't both love every part of it, but it's an arrangement that they both think they can live with. So they could then go and just write a separation agreement with lawyers, and that would be that. It would deal with custody and access. Maybe it would also deal with child support and other issues. Or if they want, they can have it made into an order. Either way, it's legally binding.
Thank you, Pam. The next question. Sometimes children get physically ill when they have to go visit their fathers. Should they not take that into account or take into account the child's feelings?
One of the factors in the best interests of the child test is the child's views and preferences, where those can be reasonably ascertained. There's no magic age in law that says once a child is, let's say, 14, they can decide on their own whether or not to spend time with a parent. But certainly as children get older, their views and preferences are given increasing weight, because kids have their own minds. Any of you who are parents will know that. And it doesn't necessarily mean that the other parent is a bad parent, just that this child doesn't really want to spend time with that parent for now. What the courts try to guard against is this kind of situation where one parent is intentionally turning the child against the other parent because they have their own hard feelings towards that other parent. So if a child is returning from access visits regularly, not well, or is on the day that access is about to happen, is acting out, has a stomach upset, whatever it might be, it's important for the primary parent, let's say the mother, to document that so that she then can show her lawyer, look, there's a pattern here. It's not that it just happened once. If it's serious enough, she can go back to court and ask for a change to the access arrangement based on the fact that it doesn't appear to be in the best interest of the child. Those are not easy cases to win, I'll be honest with you, because judges believe very strongly that children should be spending time with both of their parents. But certainly it's something that the primary parent can raise with the court if there's evidence that the children are really reacting poorly to spending time with their other parent.
Thank you, Pam. This question is similar, but just in case you'd like to add, this question states, I often ask parents what they would do if their child gets physically ill when they have to go to school.
Well, that's kind of out of the bailiwick of family law. If a child gets physically ill when they have to go to school, it may be that it's time to hook the child up with an appointment with the family doctor, maybe with a child psychologist, to find out what it is that's going on at school that's making the child not comfortable going there.
Thank you. This participant said, thank you for the examples. What about Turkey? Can they do convention application?
I believe that Turkey has signed the Hague Convention, in which case, yes. But the best way, I don't carry around in my head the list of all the countries that have and have not signed the Hague Convention, but you can Google this very easily. If you Google either, has Turkey or has Qatar or whatever you want signed the Hague Convention, good old Google will give you the answer.
Thanks again, Pam. Next question is, what if a father returns to a majority Muslim country with the children and doesn't want to return to Canada? What can the mother do to get her children back in Canada?
If that Muslim majority country has not signed the Hague Convention, so let's assume that that's the case first, then obviously the mother can't use that international law to assist her. It depends on what the country is. In some countries, if she herself goes there and she's still married to her husband, she may not be able to leave herself because there are some countries where the husband has to give permission for the wife to leave the country. So even though I'm sure that's the first step that most mothers would want to take to get as close to their children as they can, it's important for the woman to find out a little bit about what the family laws of that country are before she goes there. She may need to hire a lawyer in that country and herself stay in Canada, and then she would have to use the family law of that country to try to have her children returned. If she had a custody order in Canada that said she had sole custody, if the order also further set out that the father wasn't allowed to remove the children from Canada, that would be evidence in the case in the Muslim majority country. But depending on the country, it may not be evidence that the court in that country takes seriously. It's a really bad situation when a child is removed to a country that has not signed the Hague Convention. It's very difficult to get children back from those countries. The federal government of Canada has some really good resources that you can find online about steps that a parent can take to try to prevent the child from being taken out of Canada in the first place. So, for instance, if a woman is getting a divorce or getting a custody order, and she has concerns that this might happen. The father's family lives in a country that has not signed the Hague Convention. He has business interests there. He owns property there. He has work that he could do from there as easily as from Canada. Perhaps he's threatened during the marriage that if you ever leave me, I'm going to take the kids back to my parents and you'll never see them again. Then she needs to raise that as evidence in her custody case. And the order can itself prohibit the father from taking the children out of the country, can ensure that he doesn't have the children's passports, but rather the mother has those passports, and can even put a red alert on the border so that if anyone with the father's name or the children's names tries to cross the border, they're stopped, they're questioned, and if it turns out it's the same people, they can be prevented from leaving the country. So this is definitely a situation where preventing the child from leaving Canada is better than trying to get the child back after. If I could just say one more thing about this, it's not an uncommon tactic for a man who's been abusive to his wife and who has connections, family or otherwise, in a country that has not signed the Hague Convention. It's not uncommon for a man like that to claim to be taking the child on a vacation. Let's say, I'd like to take our children to Paris for a summer vacation. And the mother says, sure. And it's all set out in paper. They're to be gone for 2 weeks. She has their cell phone number so she can talk to them every couple of days. Off they go. Now they're in Paris. The father has the children's passports, and he can jump off from there to anywhere that he wants, including to a country that hasn't signed the Hague Convention. So, where women are concerned about an ex-partner having ties to such a country, and where any threats at all have been made throughout the marriage about removing kids from Canada, those women need to be very, very careful about consenting to any travel at all outside Canada.
Thanks kindly, Pam. The next question is if the father was paying full child support but recently lost his job, do the parents need to go back to the court to get the issue resolved?
Not if the mother is understanding. So if she knows that he's lost his job, obviously she knows he's not able to pay child support. If the child support is an order, they can consent. The mother can consent to a temporary suspension of child support or having it reduced to $5 a month or something like that. But they'll still have to go back to court. It's called on a consent order, so they don't have to go in front of the judge and argue because they're both agreeing to the same outcome. But they need to have a new order issued because the Family Responsibility Office, as it's called in Ontario, and there's similar entities in the other provinces, they're just going to keep taking that money out of his bank account until they see a new court order that says, stop, as of June 1st, this man was not working, and so he doesn't have a responsibility to pay child support for now. So as the family responsibility is going in and grabbing that money, once that's all gone, there's no more money in his bank account, he will begin to build up what are called arrears, and it's very difficult to get rid of those later. So even if the two people can agree, yes, we're going to reduce the amount of child support or we're going to stop the amount of child support for a period of time, they do still have to go through the mechanics of getting a new order from the court that can be filed with the enforcement office.
Thank you. The next one is rather long and may just need legal advice instead of information, but I'm going to try to summarize it in case Pam, you'd like to comment on it. But this
Sure.
person has three kids and is now back in Canada. Prior to this, she was in Canada and received abuse from her husband at the time. Her husband is no longer in Canada, and she doesn't know if he will come. He sends frequent emails. And so her questions are, can I ask the court to have all rights to take decisions for my children? And if he refuses to pay any support, what actions can I take if he sets foot in Canada? And how can I protect myself and my kids from him if he were to come back? Can I request an order from the court to protect the kids from him, allowing him to visit, but short visits in the presence of a third person? And sorry, Pam, I know that was a lot, but
Oh, no, that's fine. I'm going to make some general comments about that, but anybody who's in this kind of situation really needs to meet with a lawyer. And if you don't have the financial ability to pay for your own lawyer, you can apply for a legal aid certificate from Legal Aid Ontario. Right now is a great time to do that because during the pandemic, legal aid has suspended all eligibility requirements for survivors of domestic violence. But in terms of just a couple of general comments, certainly this is a situation where it would be a good idea for the mother to apply for custody of the children and could suggest that access either not happen or that it be supervised given the history. She could also ask for a child support order if she knows anything at all about the father's income. And then that order would be enforceable against him now if he lives in a country or is staying in a country that has one of these reciprocal payment agreements with Canada. If not, it would be enforceable when he comes to Canada. And if she has concerns for her safety or the children's safety, then at the same time she could be making an application to the court for a restraining order. And she'd say, he's not in Canada right now, but he could show up at any time. She needs evidence to convince the court that she has a reasonable fear for her safety in order to get a restraining order. So this is a case that probably should wind up in a court. It's ideal if the woman has a lawyer who can give her proper legal advice and then represent her. And she's probably going to be making an application for custody of the children, possibly for child support, possibly for spousal support. And it sounds like probably also making an application for a restraining order.
thank you, Pam. This question says, my kids don't really know the father. I had my older son 5 years before and outside of marriage, and the dad was never in the picture. And then he came back and wanted to marry after 5 years. They got separated after 8 months. I have a second child with him, so really both my kids don't know him. If he were to come for visitation, should I send them? It's like seeing a stranger for them.
Well, that's a really interesting question. And again, my comments are information only, not advice. This is like the previous situation, one where it would be a really good idea for the mother to meet with a lawyer. If the father's name is on the children's birth certificates, then he would certainly be in a position to go to court and say either that he wants custody of the kids or that he wants to have access to them. If his name is not on the birth certificate, his status is a little less certain. But I think that this is a good situation for the mother to consider the possibility of going to court to get an order for custody. And some of her evidence will be that the father has never really played a role in the children's lives. So that the status quo, and courts love to maintain the status quo is that the children really only know their mother. And so they should continue to live with her. It really depends on whether the children might want to see the father. they may not know him very well, but maybe they'd be happy to see him for a couple of hours, a couple times a month. And so she really, I think, needs to speak with a lawyer and consider applying for custody. And she, as part of that, she could also set out what she would like the court to consider with respect to any possible access by the father.
Thank you. This question, I'm just going to read it verbatim. Where is the Hague application brought?
That's a great question. It's brought in the country where the children are now. So if the children start out in Canada and that's their habitual residence, and one parent takes them, let's just say on vacation to Paris and then says, haha, I'm not coming back, the Hague application is made in France. If, on the other hand, the family is living in another country and then one parent brings the children to Canada, supposedly for a vacation, and then doesn't return them, the Hague application would be brought in Canada. So it happens in the country where the children are now.
Great, thank you. If the father does not pay the child support, does it shift his right to access in the new law? If the parents have mental health issues which will impact the well-being of the child, will the new law give close family members to take without child protection involvement?
Okay, two very different questions. First of all, the payment of child support is not tied to access at all. So you can have access even if you're in default on your child support payments. But also the opposite is true. Just because you're paying child support doesn't mean you have an automatic right to see your children. Those are two separate determinations. Whether or not that parent can see the children is based on an assessment of what's in the best interest of the children. So support and time with the children are considered to be completely separate legal issues. And that has nothing to do with the new law. That's the way it is already, and it will continue to be that way. With respect to if a parent or parents have serious mental health issues, certainly if the court thinks it's in the best interest of the child for the children to live with an aunt or grandparents, that's an arrangement that the court can make. The right, and I use that term in quotation marks, of non-parents to play a guardianship role with children is set out much more explicitly in the new Divorce Act than in the existing Divorce Act. And in most provincial and territorial laws, there is a section that looks at the rights of non-parents to play a role in play a role in the lives of, say, grandchildren or nieces or nephews. Again, anybody who's in that situation would really be well advised to get legal advice.
Thank you. In the best interest of time, it's already 2:14, so we have 1 minute left, and we do want to say our closing remarks. Pam, did you want to?
I want to answer this one question. Do Canadian authorities screen when a parent's boarding an international flight with their children, but without the other parent? Well, they have the opportunity to screen, but they don't always do it. Any parent who's traveling across a border, whether in a car, in a plane, on a train, should be carrying a statutory declaration, which is a legal document that's been signed by the other parent, granting permission for the children to travel with that parent. Unfortunately, the border authorities don't always ask for that document, but if you don't have it and they do ask for it, they can and will turn you back. I wish they would automatically ask, whether it's a parent or a grandparent or an aunt or uncle who's traveling with the child. I wish that the authorities would always ask for confirmation, legal confirmation that they have the right to take those children outside Canada, but that doesn't seem to be the case right now. So back to you, Sabrine, to take us through the wrapping up of this webinar.
Great. So right before we end, we do ask that you take into consideration the evaluation link that will be emailed to you shortly. We try very hard to listen to our community members and those who join us and participate. And we try to be as reflective and reflexive as possible. And these evaluations help us to do so. So please do fill it out when you do get that email later on today. And thank you all for joining. Thank you to Pamela for the excellent webinar facilitation once again. You have asked in previous webinars for the Islamic scholar to join us as well. So Omar will be joining us in the upcoming webinars. Please join our mailing list if you would like more updates to register. And the questions that we have missed, we are saving them and creating an FAQ that we will be sharing with each of you. So thank you again for taking the time out. Thank you again, Pam, and we hope to see you all next Tuesday. Take care, everybody.
Bye-bye, everyone.